Back. Les Naiman, the Les Naiman Show here, 970 WGTK in Louisville, Kentucky. It is my privilege now to bring you two guests who were on last month with a great story of a lawsuit against the Congress of the United States and President Barack Obama, Commander Charles Kerchner and his attorney Mario Apuzzo. How are you tonight, gentlemen?
Fine. This is Commander Kerchner. I'm doing fine.
That's great.
How are you, Les? My pleasure to be with you and your listeners.
Same here, Mario. It's always good to hear a northern New Jersey accent, too, I'll tell you.
That's me.
Well, how is everything? Why don't you bring my audience up to speed on what is going on with your lawsuit? I know there's some things happening. Why don't you share that with us?
All right, well,
can I just quick put out the website real quick?
Absolutely.
For the people that are joining us, before we start, we have a website, www.protectourliberty.org, where you can see all the Washington Times ads we're running. We've got a new one coming out tomorrow on Obama Flaunts the Constitution is the headline tomorrow. And the Mario Apuzzo legal blog is Apuzzo1, that's P-U-Z-O 1-blogspot.com, or they can reach that via the protectourliberty.org website. Right on top there's a link to Mario's legal blog. Thank you, Les.
Hey, my pleasure. So what's been going on with the suit?
Well, okay. To make it simple to understand, basically we are right now in the Third Circuit Court of Appeals, which is located in Philadelphia, because the action was initially filed in the Federal District Court in New Jersey. It was dismissed by the court on the motion by Obama and Congress, saying that the plaintiffs, and one of which we have with us tonight, Commander Kerchner, that the plaintiffs do not have standing to bring this action. And basically it means that they can't show that they've suffered an injury, given what Obama and Congress did. They're saying that because everybody in the whole country has potentially suffered an injury, that nobody can bring this action. That's how absurd this thing gets.
They can violate the Constitution, and the people can do nothing about it.
So, go ahead.
Yeah, so the court grants the motion and dismissed the case, and we filed the appeal in the Third Circuit, which is in Philadelphia, and right now it's there. I have my what is called a reply brief that's going to be due on March the 22nd. What that means is this, that I filed my brief. It's called the opening brief. I'm arguing why the court made errors in dismissing this case. They filed their opposition brief just lately, and their opposition brief is basically a repeat of what happened below, and they don't really address our case. They just simply say, oh, there's no standing, dismiss it. So now I'm going to be filing my reply to that. And then once all that is done, then the court will be in a position to have all arguments and to decide the case. And then from there, it could go to the U.S. Supreme Court. Like, for example, if the Third Circuit agrees with the lower court, then we're going to be going to the Supreme Court, of course, in Washington on the case. So that's where it is right now.
And if they agree with us, it goes back to trial, and we go to discovery, and Obama, you start showing the stuff you've been hiding.
Well, what is the makeup politically of the Third Circuit Court there of Appeals in Philadelphia? Is it mostly liberals, or is it evenly dispersed between liberals and conservatives?
Charlie, you want to address that?
Yeah, the chief judge, when I looked at it, was a Reagan appointee, and the rest of them are about 50. There's 15 members. I think there's one seat open yet. There's one Obama appointee on there right now, and a recent one, and the rest it's about 50-50, Clinton and Bush appointees.
So it's pretty much. The sad thing about our court system now, and more.
One thing, Lester, we're going to get assigned a three judge panel to see this case. We won't be in front of all 15.
Do you know who they are yet?
No.
Oh, okay.
Mario can explain that, but I think it's kind of a random thing, or does the chief judge assign them?
How's that work, Mario?
Yeah, it's a random thing. We really don't know who we're going to get.
And on 970 WGTK.
We're back. Les Naiman here with Dan Blanchard in studio, and we have Commander Charles Kerchner and Mario Apuzzo speaking about, updating us about their lawsuits against the Congress of the United States and President Barack Hussein Obama. I think a lot of people
I like to call him the putative President Barack Hussein Obama.
Now, why do you do that?
Putative is he alleges he's the president. I don't believe he is legally the president.
Well, I would believe I agree with you on that. I think a lot of people, think that this lawsuit possibly will be about the fact that he was. You might think wasn't born in the United States or wasn't born in Hawaii. Can you just go over that one more time for my audience and why is this happening?
The eligibility clause in Article 2, Section 1, Clause 5 says he has to be amongst three things: a natural-born citizen. And natural-born, those two adjectives, natural-born, a citizen, doesn't mean he has to be a citizen of the United States. That's one part, but he has to be a natural-born citizen. And the word natural comes from natural law, which means both your parents must be citizens. And that was based on a legal treatise written back in the time of the Revolution and the writing of the Constitution, and it was cited in 4 Supreme Court justice cases, the law of nations or principles of natural law. A natural-born citizen, it literally says that a natural-born citizen must be born in the country to two citizens of the country, parents who are citizens of the country. That's a natural-born. You don't need any piece of paper or court decision. You don't have to go to the courts to prove you're a citizen if you're a natural-born citizen. You don't need any legal laws to explain it. You're given in that position and status by the laws of nature, the laws of nations. In other words, if you're born in the tribe to people of that tribe, you're a member of the tribe. It goes back for as long as there's been civilization. If you're natural born, there's no question. You don't need a piece of paper to make you a citizen of that country. And natural borns are 95% of the American people are natural born. They were born here to citizens of America. Obama's not one. His father was never a citizen, not even an immigrant to this country. It's been said on TV and radio, son of an immigrant for Obama. No, he's not the son of an immigrant. His father was not an immigrant. His father never even was a permanent resident. Here for a few years to go to college. He got a girl much younger than him pregnant. They say he was married, but we never found a marriage license to prove that. But
another missing document
is the son of a British subject, and that makes Obama, by natural law, a British subject, and by British law, a British subject.
And also,
what's very important to understand is there's a dispute as to what defines the natural-born citizen. The OBOT camp, I call them the OBOT because they call us every name in a book, so we're entitled to call them the OBOTs.
But we call ourselves constitutionalists, if you want to put a name on us. We're constitutionalists.
Mm-hmm.
Yeah. They say that the English common law defined a natural-born citizen, the English common law. And we say no. It wasn't the English common law. It was natural law and the law of nations. And we had people like Pufendorf, Burlamaqui, and especially Vattel. These are three writers on natural law and the law of nations. And the founders relied upon these particular writers, their treatises. They used these books to guide them in creating the new nation, the new constitutional republic, and they also used them for citizenship. And like Charlie said, there are Supreme Court cases that cite the natural law and the law of nations when they define a natural-born citizen. So the big battle is, was it the English common law or was it natural law and the law of nations as per Vattel that defines a natural-born citizen? We have evidence that it was Vattel, and therefore there's where you have your definition of a natural-born citizen, which is born in the country of two citizen parents. The OBOT camp, they completely ignore that the founding fathers were writing the Constitution in the historical context of a revolution having just been completed. Okay?
So in other words, what that means is that England. They just threw off the English government as our power. We didn't want them to be involved.
Let me ask you a question real quick. Is there any precedent in any other Supreme Court decisions on anything like this?
Yeah, there's cases starting with Chief Justice John Marshall, which is the Venus case in 1814. He cites the natural law definition. He calls them the naturals or the indigenous, are born in the country of citizen parents. That's Chief Justice Marshall, who's one of the major founders and also, of course, one of the most important justices